See.
Some people have got 10 minutes.
Yeah.
The edits in that matter.
Where? So Mwaridi is also present.
Appear together with Dr. Hamino for the petitioners.
So I will start now. First petitioner's affidavit, Dr. Annette Bogo. Petitioner's affidavit, Dr. Annette Bogo. And second petition is founded on the petitioner's Bogo. And second petition is founded on the petitioner's assertion that the 1988 U.S. Embassy bomb attack is attack. U.S. Embassy bomb attack is attack. The petitioners that contend that the Kenyan government failed to discharge its domestic and international obligation. Others were maimed, and others suffered serious psychological trauma as a result of the said terrorist, which I will not go through because they are very well set out in the petition. Hence, it lined up upon by the petitioners, that is the reports, publications, and judgments by courts in the United States, obligation to protect Kenyans against the Al-Qaeda attack that targeted. Depending on the answer to the issue number 2 above, if the respondents violating the petitioner's constitutional rights, subsection A, 71, subsection 1, and 29 of the Constitution, and whether they have an obligation to pay the compensation should be formed. And number 5, whether the the reliefs sought. Those are the only issues that in this judgment. So I will start with the issue number 1. Whether there was inordinate delay in bother to explain on the case of Wellington Nzioka Kioko versus Attorney General to buttress this point, and long-lasting effects on health of the victims, including death and lifelong incapacity. Hence, considering the gravity of the impact, the petitioners prioritized their health prior to seeking justice. This caused a massive financial strain that impacted on their ability to file this suit promptly. That this fact is what informed the petitioner's decision to approach the first petitioner for legal assistance. Moreover, they argued that in the case of Eliud Wefafwa Rucho and 3 others versus Attorney General, and in the case of Nairobi Legal Advice Center Kitosa Sheria versus AG and others, and Wamwere and 5 others versus AG, it was held that limitation of time does not apply in respect of matters alleging breach of fundamental rights. Judicial precedents have now firmly established that in cases involving violation in respect of human rights, they are not affected by limitation of time so long as a delay in instituting the case has been satisfactorily explained to the court. That was a finding of the court in Dambuki versus Dungu and others, which is a High Court decision. It's a long quotation, I will not go through it. Then there was also another case of Pitangari, Karume, and others versus AG, which was also on the same point. In the instant case, the petitioners have given reasons why they delayed in taking legal action. One is that they had been in constant engagement with the respondents over the years, with the respondent giving them hope that their matter was under consideration. The respondents did not deny that they had engaged in some discussions with the petitioners on the issue for years with a view to finding a solution. Further, the petitioners cited the fact that they had been experiencing financial challenges as there are demands on them in terms of health expenses. As a result, they had to approach the first petitioner for legal assistance to pursue this matter on their behalf. Despite the respondents claiming that they have suffered prejudice as a result of delay in filing this petition by the petitioners, they did not contest the fact that they have been engaging in a conversation around the issue with the petitioners for several years. They cannot thus face surprise of the issues at hand. Further, they did not articulate the exact nature of prejudice that they have suffered in defending the petition, other than making the general statement. I find the explanation given by the petitioners for the delay in filing the petition as satisfactory, hence the delay in filing the petition is thus valid and excusable. I will now go to the issue number 2, which is whether, in the light of the evidence relied upon by the petitioners, which are reports, publications, and judgment by courts in the United States, and the totality of the circumstances of this case, the petitioners have established, on a balance of probabilities, that the government of Kenya failed to discharge its positive obligation to protect Kenyans against the Al-Qaeda attack that targeted the United States Embassy in Nairobi in 1998. This is the foundational issue upon the petition rests. The resolution of this issue will determine whether the court can consider the other issues in the question of liability in respect of the actions complained of. President's failure to take reasonable steps to prevent the occurrence of the U.S. Embassy appended. It was also the respondent's position that the petitioners did not adduce any evidence to the effect that the Kenyan borders were not well guarded and that the persons entering were not being properly vetted. This applies to the allegation of smuggled money under the government's nose. Further, the respondents informed this court that the government was absolved from liability for this attack in the earlier case of Otolo Mangit Kanini and others versus Attorney General and others. Furthermore, it was the respondent's case that after the bomb attack happened, the government coordinated the initial rescue efforts and later efforts by local and international NGOs. The government as well coordinated the emergency assistance from Israeli Defense Forces, the United Kingdom, France, Denmark, Japan, and United Nations. That the then president, His Excellency Daniel Arap Moi, set up the National Disaster Emergency Fund known as Jojo Fund. This fund received and dispersed funds to the victims and their families so as to cater for the funeral expenses and also compensation. As such, the respondents argue that the government expended every effort to ameliorate the conditions of the victims and their families. Additionally, suspects associated with the attack were also apprehended, charged, convicted, sentenced, and imprisoned in the U.S. as per Annexure AM7, here to mark KK3 and KK4. It is important from the outset that I lay bare domestic and international obligations of the state, then proceed to assess if the petitioner has established the threshold of probability or the threshold of liability against the respondents. The finding of liability is important because, if established, it will inform the next action by the court. Under the Repealed Police Act, Cap 84, the functions of the police were prescribed to be as follows. Section 14, subsection 1 states, and I quote, "The force shall be employed in Kenya for the maintenance of law and order, the preservation of peace, the protection of life and property, the prevention and detection of crime, the apprehension of offenders, and the enforcement of all laws and regulations with which it is charged." End of quote. The relevant sections of the repealed Constitution of Kenya provided as follows. Section 70. Whereas every person in Kenya is entitled to the fundamental rights and freedoms of the individual, that is to say, the right, whatever is race, tribe, place of origin or residence, or other local connection, political opinions, color, creed, or sex, but subject to respect for rights and freedoms of others and for the public interest, to each and all of the following, namely, life, liberty, security of the person, and the protection of the law. Section 71 of the repealed Constitution stated, "No person shall be deprived of his life intentionally, save in execution of the sentence of a court in respect of criminal offense under the law of Kenya of which he has been convicted." Section 74(1), on the other hand, said, "No person shall be subject to torture or to inhuman or degrading punishment or other treatment." Subsection 2, "Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section to the extent that the law in question authorizes the infliction of any description of punishment, that was lawful in Kenya as on 11th of December 1963. The African Charter on Human Rights, on Human and People's Rights provides at Article 4 and 6 as follows. Human beings are inviolable. Every human being shall be entitled to respect for his life and the integrity of his person. No one may be arbitrarily deprived of this right. Article 6 of the African Charter on Human and People's Rights says, every individual shall have the right to liberty and to the security of his person. No one may be deprived of this freedom except for reasons and conditions previously laid down by law. In particular, no one may be arbitrarily arrested or detained. In the Universal Declaration of Human Rights, Article 3 proclaims thus, everyone has a right to life, liberty, and security of the person. The issue of holding the state liable for the failure to take realistic steps to stop violation of human rights was discussed in the case of Otoro Margaret Kanini and others versus AG, where, citing petition 132 of 2011 and 197 of 2012, consolidated, the court addressed itself on the scope of liability of police under Section 14 of the Police Act, where the failure to protect citizens is alleged. The court said as follows, and I quote, "It is our view that Section 14 of the Police Service Act and now Section 24 of the National Police Service Act impose a negative obligation on the part of the government in general and the police in particular not to violate the rights and fundamental freedoms, but also imposes a positive obligation on the part of the state agencies to protect the people from the threat of violation of the state rights and fundamental freedoms. To this extent, and as to whether the state is liable for violations of fundamental rights and freedoms by private or third parties, we are guided by the decision in Association of Victims of Post-Electoral Violence and Interrights versus Cameroon, where it was held that the respect for rights imposes on the state the negative obligation of doing nothing to violate the said rights. The protection targets the positive obligation of the state to guarantee that private individuals do not violate these rights. In this context, the Commission ruled that negligence of a state to guarantee the protection of the rights of the Charter, having given rise to the violation of the said rights, constitutes a violation of rights of the Charter, which would be attributable to the state even where it is established that the state itself or its officials are not directly responsible for such violations, but have been perpetrated by private individuals. According to the permanent jurisprudence of the Commission, Article 1 imposes restrictions on the authority of the state institutions in relation to the recognized rights. This article places on the state parties the positive obligation of preventing and punishing the violation by private individuals of the rights prescribed by the Charter. Thus, any illegal act carried out by an individual against the rights guaranteed and not directly attributed to the state can constitute, as had been indicated earlier, a cause of international responsibility of the state, not because it has itself committed the act in question, but because it has failed to exercise the consciousness required to prevent it from happening and for not having been able to take appropriate measures to pay compensation for the prejudice suffered by the victims." End of quote. Under the present constitutional dispensation, the obligation placed on the state is more direct and clear. Article 21, Article 1 of the Constitution provides as follows. It is a fundamental duty of the state and every state organ to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. This constitutional obligation underscores the fact that the state is not only required to desist from violating the fundamental rights and freedoms, but must also take positive steps to prevent violations by others and also facilitate the realization of socio-economic rights. This is a constitutional command. The question thus becomes, have the petitioners demonstrated by way of evidence and on a balance of probabilities that the government of Kenya knew or ought to have known or ought to have reasonably known of the risk of occurrence of 1998 bombing of U.S. Embassy, and being so aware, failed to take reasonable steps to prevent its citizens from being attacked? Under Section 107 1 of the Evidence Act, Cap 80, the burden of proof lies on the person who asserts the existence of a fact. It states, and I quote, "Whoever desires any court to give judgment as to any legal right or liability dependent on the existence of facts which he asserts must prove that those facts exist." The Supreme Court, in Guer and 5 others, was the Kenya Medical Research Institute, elaborated and affirmed this principle thus, and I quote, "Section 108 of the Evidence Act provides that the burden of proof in a suit or procedure lies on that person who would fail if no evidence at all were given on either side. And Section 109 of the Act declares that the burden of proof as to any particular fact lies on the person who wishes the court to believe in its existence unless it is provided by any law that the proof of that fact shall lie on any particular person." The court in Raila Odinga and 5 others was Independent Electoral Boundaries Commission and others, Petition 5 of 2013, restating the basic principle, the basic rule on shifting of the evidential burden in these terms, and says, a petition should be under obligation to discharge the initial burden of proof before the respondents are invited to bear the evidential burden. Have the petitioners discharged this burden of proof through credible and admissible evidence? To discharge the burden, it is my humble view that the petitioners had an obligation to satisfy this court on a balance of probabilities on these 4 elements. Number 1, there was specific credible intelligence at the government's disposal. Number 2, the government had the opportunity to act on it. Number 3, that the government failed to take reasonable steps to prevent the occurrence of the act complained of, despite being in possession of credible intelligence at its disposal. And number 5, that the failure caused or materially contributed to the terrorist attack. If the petitioners succeed in proving those 5 elements, then their case will succeed. If they do not, then the case will fail. Then the next question is there sufficient evidence on record to establish the above elements? I have to examine the petitioner's evidence on record vis-a-vis the rebuttal by the respondents. It is apparent that what the petitioners solely rely on are statements in publications and reports to establish negligence on the part of the state to prevent the attack. The authors of these reports and publications were neither called to testify, nor did they file affidavits authenticating the contents of those reports. The facts they relied on to arrive at the conclusion in those reports cannot be verified either. Basically, it is hearsay evidence. The publications and reports presented in this manner cannot constitute credible and substantive evidence of the disputed fact of reliability. Moreover, the petitioners relied on the contents of judgments from the United States. The court thus acknowledged the existence of the said judgments, but the findings of fact by another court cannot be taken as proof in any other subsequent judicial proceeding. In any event, I've gone through the said judgments carefully, and I do not find anywhere where the American courts made findings faulting the government of Kenya for negligence or complicity in the U.S. Embassy terrorist attack by Al-Qaeda terrorists. Indeed, despite annexing the said judgments, the petitioners did not point any such finding against the government of Kenya in any of the American court judgments. All that was clear was that the American courts squarely placed responsibility of the attack on the Republic of Sudan. In my view, the ES statements in the reports cannot be relied upon as substantive evidence to prove disputed evidential facts that the government of Kenya failed to act on prior intelligence. This is more so when the state has vehemently contested this assertion and has stated that it was not in possession of any specific actionable intelligence, only generic information of heightened terrorism activities in the region, and that it acted on it in the best way possible under the circumstances. There is thus no demonstrable credible evidence that Kenya received prior multiple specific actionable intelligence reports about the impending U.S. Embassy bombing, but the truth of the fact turns out to be ES statements. The sources of facts that made the authors come to the conclusions contained in the reports cannot be verified, as not even the authors of those reports swore affidavits to authenticate the reports and publications relied upon by the petitioners. On a balance of probabilities, I would not regard this as credible evidence to be used as a basis of finding liability. Without evidence that establishes the respondent's failure to take reasonable steps to stop the U.S. Embassy terrorist attack in August 1998, the substratum upon which the petition is founded cannot hold. The violations of constitutional rights against the state depended on proof of this primary fact. A similar scenario played out in the case of Otolo Margaret Kanini and 16 others versus Attorney General and others, which was also a constitutional petition based on 1998 bomb blast attack. The factual foundation was also similar, that the petitioners were spouses and children of victims of 1998 U.S. Embassy terrorist attack. They accused the respondents of failing to forestall any and all preparatory activities that led to the egregious attack, and as a result, petitioners' kings lost their lives, leading to the violation of petitioner rights and fundamental freedoms. The court held as follows, and I quote, "A candid look at the petition reveals that it was based on hearsay, but even by taking into account the fact that the respondents accepted the alleged intelligence reports, the petitioners did not adduce any evidence to dispel the respondents' position that the reports were of general nature and could not be relied upon to prevent the attack. The petitioners' averments remain hollow. This court finds and holds that the petitioners failed to prove the respondents acted in a manner so as to endanger the lives of the persons who died out of the bomb attack. There being no liability on the part of the respondents as discussed above, the issue as to whether the rights and fundamental freedoms of the petitioners as pleaded in the petition subject to this judgment were infringed as a result of the persons who died during the bomb does not arise. This court returns the finding that the petitioners failed to prove that their rights under Articles 26, 27, 28, 29, and 43 of the Constitution were variously infringed. The issue is hereby answered in the negative. Besides alleging violation of fundamental rights and freedoms, the petitioners have prayed for a declaration in the following terms, and I quote, "A declaratory order directed at the Attorney General to advise the President to set up a commission of inquiry to inquire on the security failures leading to 1998 U.S. Embassy terrorist attack, culpability of state institutions and state officers in the attack, and recommendations for their prosecution." End of quote. Under the Commission of Inquiry Act, Cap 2, the President is granted the power to establish a commission of inquiry as follows, and I quote, "Issue of commission of inquiry. The President, whenever he considers it advisable so to do, may issue a commission under this Act appointing a commissioner or commissioners and authorizing him or them or any specified quorum of them to inquire into the conduct of any public officer or the conduct or management of any public body, or into any matter into which an inquiry would, in the opinion of the President, be in the public interest." From the introductory wording of Section 3, subsection 1, it is crystal clear that the matter of establishing a commission of inquiry lies with the President exclusively. The Act does not mention that this shall be on the advice or recommendation of anyone, let alone the Attorney General. It is exclusively executive discretion. Further, an examination of the functions of the Attorney General under Articles 156(4), A, B, C, 5 and 6, including under the Attorney General's Act, none confers such express mandate on the Attorney General. Were this court to assume the task of telling the Attorney General to give specific legal advice, that would be akin to meddling with the independence of that office. Further, as already found, that is a matter clearly not explicitly covered under the statutory or constitutional duties of the Attorney General. The prayer as framed is thus legally incapable of being granted. Neither the Attorney General can be compelled to advise the President in the absence of any explicit statutory or constitutional provision assigning him any advisory role to the President in establishing commissions of inquiry, nor would the President be so compelled as the Act gives the President the discretionary mandate to decide whether to establish or not. I am fortified in this regard by the decision of Apollo Boyer versus Attorney General, where the court stated as follows. From the reading of Section 3(1) of the Commission of Inquiry Act, I find no provision stipulating that the President of the Republic of Kenya can be compelled or supervised to discharge his mandate as provided under the aforesaid Section 3 of the Commission of Inquiry Act. The President of the Republic of Kenya is the end of the executive, and it discharges mandate independently under the doctrine of separation of powers. Section 3 of the Commission of Inquiry Act is not couched in a mandatory form, and as such, the President is at liberty to exercise his powers at his own discretion and at his own time, and when he deems fit to do so. Lastly, there were prayers as follows. An order directed at the Attorney General to, within 6 months of the court judgment, present a report to the court on the steps taken by the government. 1. To file an international jurisdiction case for compensation of all victims and their families against the Republic of Sudan and Iran, and or steps taken to obtain reparations from those countries. 2. Obtain compensation for victims from Al-Qaeda assets and BNP Paribas, SA, BNPP, and global financial institution headquartered in Paris. And number 3, seek acknowledgement of responsibility from the Republics of Sudan and Iran. The prayers are not aligned to the mandate, as it could have massive foreign relation implications between Kenya and affected states. A three-judge bench in Kiriro Ngugi versus Attorney General sounded a word of caution while reviewing the action Reuters publishers at page 1346 defines it as the judicial principle that a court should refuse to decide an issue involving the discretionary power. Reuters publishers at page 1346 defines it as the judicial principle that a court should refuse to decide an issue involving the discretionary power of the executive or legislative branch of government. The political question doctrine focuses on the limitations upon adjudication by courts of matters generally within the area of responsibility of other arms of government. Consequently, the court concluded as follows. According to the political question doctrine, certain sets of issues categorized as political questions, even though they may include legal issues, are considered to be external to the judiciary and handed over to the other branches of government for adjudication. The doctrine therefore focuses on limiting of adjudication of disputes by courts in favor of the legislative and executive interventions. It is underpinned by the concept of separation of powers. All that the courts are doing in such situations is assigning discretion on the issue to another arm of government. In the United States case of Eckler versus Chaney, death row inmates challenged Food and Drugs Administration refusal to initiate the enforcement action to block the use of certain drugs in lethal injection. The Supreme Court did not agree with the case of the inmates on the grounds that the drug agency's decision was dependent on complicated balancing of many factors that were peculiar within its expertise, and it was thus better adorned to evaluate those variables than the court would, hence as a matter within its discretion. The Supreme Court, however, went and made a decision on the guiding standards that may be applied against the presumption of judicial review of administrative non-enforcement decision based on discretion or deference. The Supreme Court identified specific situations where the statute has provided guidelines for agency to follow in accessing its enforcement power, stating that in such cases, the court will have been supplied with the law to apply in reviewing the decision. The other would be when administrative agency has adopted a general policy that is so extreme as to amount to abdication of statutory responsibilities. In my humble view, whether the government of Kenya should take legal action against the government of Sudan, Iran, or France or French bank BNP Paribas for their suspected involvement in the U.S. Embassy bomb plus terrorist attack of 1998 requires delicate weighing of many factors that include high-level political consequences that comes with taking such action, which this court feels restrained to take, as it requires balancing of various interests which include political and diplomatic consequences. I find that the political question doctrine thus applies on all fours in relation to the aforementioned prayers. For the reasons aforesaid, I find the petition lacks merit, and I hereby dismiss the same in its entirety. Each party shall bear its own costs.
Your Honor, on behalf of the petitioners, we are most grateful for the decision of the court. I speak for Kituo cha Sheria. I also speak for the victims, the families. I know it is a disappointment to them, but we respect the decision of the court. Your Honor, we'll be praying for a copy of the judgment to enable us advise our clients on the next steps. As we also appreciate the court for the decision that it has made, we also appreciate the fact that these victims, survivors, and their families were able to gallantly come before this honorable court, seeking accountability from the government they are so much loyal to. Your Honor, we appreciate the decision of the court. We respect it. And Your Honor, will be praying for that copy of the court judgment to consider pursuing other remedies, whether within the country or possibly outside the country. We are most grateful, Your Honor.
My Lord, with your kind permission.
Yes.
This is Weche. My apologies for logging in late. The record can reflect that I appear for the respondents. I also join my colleague, Mr. John Mwariri, in thanking the court in delivering the judgment. We also pray for a copy of the judgment to enable us to advise our client accordingly. We thank your Lordship.
I also want to take the opportunity to thank councils and the parties in this matter. It has not been easy. It was a very lengthy and complicated case. It has now come to an end. The court only followed the law and evidence, and you have the right to seek other remedies elsewhere, as you say, including pursuing an appeal. Thank you. So there is another judgment that I'm about to deliver, but it's being printed. We will give it a bit of time so that the secretary can complete the printing. That is a judgment by Katiba Institute. So we'll be able to reach out to them once the judgment is printed, but it's already in the process. Thank you.
We have done our